All right. So we are now going to give you, and just like I said, the first pass of the semester, we're going to go, this is going to be way, way up here, today's lecture, about the law. What is the law? Then we're going to kind of narrow that cone down a little bit and talk about what is a lawsuit and how does a case work. And then we're going to talk about arbitration and mediation. So we're going to go through that. So this lecture kind of applies to everything. And there will be times throughout the year, especially the environment we live in now, well, I will be referring to things that you hear on the news. I'm not doing it about a political because I don't try to put my political bent on everybody, but sometimes there's an example, like you may hear about a case or a lawsuit or whatever, and why they're relevant, so I may use those references. And so today's lecture, I may have some of this stuff and pull into it. And just as we go through, I will use examples on projects that I've worked on actual real-life cases. Some of my projects, I will not be able to tell you the name of the clients or what goes on because it may be active, or because of the relationship I have with that client, I still not allowed to talk about it even if the case has been settled, resolved. But I can give you examples of like, oh yeah, I worked on this project with this power plant, and I won't tell you what company it is, and here's what happened. Or I was working on this project site, and this guy, this worker, fell, and here's what happened, or something like that. So I try to give you real-world examples so you understand, like you can put it in context, like, oh, they can kind of see and understand it. So, the overview on the law. So the first thing we're going to talk about is the levels of government. We probably all took a government class back in high school and everything else, so this is just maybe a refresher of some civics class or something you took. But I just want to go over it so you kind of know. So there's the laws of nature. And why are we talking about, like who cares about the laws of nature? Well, you got to remember, you, as a designer, must design first and foremost to the laws of nature, because if you don't, your building's going to fall down. That's gravity. Or it's going to fall over. That's wind. Most of you probably know, or maybe don't, but with high rises, the most important force is not the gravity force, it's the wind shear after a certain level. So you must think about that. So there's the laws of nature, so that's applicable. Now, I am not here to talk about nature and those types of things, and we're not talking about physics or engineering. Just want to let you know it's relevant, and that's like the highest law way up top. There's the laws of nature. Then there's other laws that follow that. So way back when, 100 million years ago, or maybe not that long, a couple hundred, 300, 400 years ago, still sits in England, there was the monarchy. The monarchy, they decided. There was an individual, the king, and they decided whatever they wanted to do. And that was the rules. And everybody followed that rule. And you had to do it. Whether you were a worker in a field, whether you were somebody in their infantry, whether you were a servant, or whatever it was, you followed the rules of the monarchy, and that's how the government went from there. We, of course, the United States came away from it. We didn't like that, so we started bringing up, and then we came and created, although actually the next one that I have an example is democracy. Democracy, a pure democracy like they had in Greece. We are not a pure democracy, you guys, and so pulling in a reference you guys, people may have heard over the last 6 months and everything else, we are a republic. We are not a democracy. Even though we elect people and we have a democratic system, we are not a pure democracy. A pure democracy is one person, one vote, all the way across the board. That's what ancient Greece was. So that's a pure democracy. We have a republic that we use a democratic process that elects representatives. Those representatives of the republic are the voice of the people of the democracy. And then depending on who the representatives, they may, because, depending on what state or what you are in, if it's a very close state, even though they only won by 1%, they're only going to really be speaking for that 51%. And that just happens in our system and other systems. And so nothing's perfect. Other types of laws and systems we have, socialism and communism, there's various other types. We don't need to worry about those. But those are ways that people govern society and govern how you build things and how you exist and how businesses operate and everything else. So kind of way high overview. For us, a republic or a constitutional democracy, that's what we have. We have a constitution that says we the people and the people vote, but it works as a republic. And that's what so we have. It is not the concept of where the majority does not always rule. We all know, the whole electoral college doesn't necessarily mean that the true democratic majority rules. That's fine. That's the way it was set up. It's not wrong. It's just the way it happens. So, that's part of our system. But ultimately, it is still designed, and people talk about this now, like the framers way back when of Hamilton and Jefferson and the people. Anybody here saw the play Hamilton? Yeah. Like, one of the greatest things about it, I ended up reading the book after I saw the play, and while I loved the play was phenomenal and everything else, was many years later, going back and relearning stuff that you hadn't really learned. Hamilton was kind of like one of the unsung heroes because everybody knew Jefferson because he wrote the articles, the amendments, and the Constitution, and Thomas Jefferson's big signature, Hancock's big signature, and like all that stuff. Hamilton and other people, how much they were relevant. And so when I was in law school, actually, I studied the Federalist Papers, of which he wrote. I think in the play they say, and he wrote 61 of them, or whatever it was one of the lines that they sing. But these people, they created the system, but the purpose of it was to protect both the rich and the poor. It was supposed to be to make sure that this person, whether they were rich or poor, had a vote, and this person had a rich or poor. Now, the system that we work in or live in now has its flaws, which we have seen both sides of the aisle and everything else. But it's still, from its basic core intent, and what it tries and strives to do is to make sure that people are represented, and that's what we have. There are issues that you try to take. You want to make sure that whether it's geographical or race or whatever the minority is, everybody has a say. That's the purpose of the way our constitutional democracy was put together. And that's what we operate under. Now we're going to talk about the levels of government. So that's all, just so you know, and then this will be a perfect tip. Nothing on that slide is going to be an exam. I just wanted to kind of give you an overview. But I kind of like to talk a little bit about it, give you guys a little bit of flavor where we are. So, levels of government. So we have national, not federal, national government, then we have state government, and we have municipal or sometimes called local government. Okay? The national government can only exercise power that is expressly granted to it through the Constitution. Now, there are some clauses in the Constitution, like the Commerce Clause, that have huge, wide-sweeping arms that encompass many things. So you can have many national laws that apply to you, okay? But they still ultimately must derive and come from the Constitution. That's why when people go and challenge a law and go to the Supreme Court, it's challenged on its constitutional basis. And so when a law is overturned, a statutory law, national law, is overturned in the Supreme Court, it's because the Supreme Court has decided the Constitution doesn't provide within the four corners of that document for this law to say and impose what it does. So that's where, when somebody says, it's unconstitutional, it's literally someone, a group of 9 judges, saying in this rule, it is not found. We cannot figure out any spot in any of these articles and the amendments that your law fits under. Or the flip side is, we can take the writings and these laws and say it has enough expansion that it allows you to do this. And sometimes that gets into issues of sometimes it's case law, sometimes it's other things, but like and again, try not to be political, but everybody knows Roe v. Wade, and that was determined many years ago that was constitutionally allowed for these things to happen. People question that all the time. Whether they're right or wrong, I'm not here to make my decision, or certainly I have my own opinions, but that's not what I'm here for. I'm just letting you understand that at some point in time, someone looks at the Constitution, they had this law, the law was challenged, they went through the court cases, and they brought it to the Supreme Court, and the Supreme Court said, this is allowed under the four corners of the U.S. Constitution. It's a national, it's not a law, or it's not a statute that the government created, but it is allowed as a national law. What's the law of the land? The Constitution may be brought into application, and the Congress can do what they want. The Congress and what it can do. So that's this whole concept of like the Commerce Clause and everything else. So what happens is these lawmakers in Washington, since we're still talking on the national level, they create laws that apply to everywhere in the land, and what they try to do is they try to figure out, will it fit within the powers that the Constitution granted to the Congress to create a law? And obviously we have this tripartite system where the president still has to sign it, or ultimately, even after the Congress does it and the president signs it, the other party of the judiciary, they may say it's right or wrong. So the checks and balances concept. So that's national level, and it applies to everyone. Okay? Now, interestingly enough, state laws are wholly and separate to themselves. I can have a law here, and it has nothing to do with the law in Michigan. Most talked about law in Illinois this year just came into effect. The 11th state in the country to allow you to buy cannabis products. 11 states. It is illegal under the federal rules. Buying and selling and smoking or eating anything with marijuana or cannabis or anything else is federally a crime. But there are 11 states that allow it. How does that work? It's interesting, because one of the first states that did this, and I just actually learned this on Wednesday, I didn't know this, because I have a friend of mine who's been to all 11 states, so she knows all about this stuff. And she said, for the money, so this is out in Colorado. So Colorado I think it was the first state that legalized marijuana. And you cannot use the banking system. So a lot of these startups, they all work on cash. Because if you get a check, you have to take that check to a bank. And the bank is licensed under the FDIC. And under the FDIC, they are not allowed to accept a check or process funds that are for the sale of something that's illegal federally. So apparently, this is what I learned on Wednesday, there's the first national bank of weed in Colorado. And it was a guy that had a lot of money, and he literally hand processes checks. I don't know how it works. I don't know if he has a big vault or something, but he takes checks from people, real checks, and he processes them. It never goes through the federal banking system. And you can get loans to start up your company if you want to get loans to buy more product and everything else. And my friend told me it's called the First National Bank of Weed. That's how a state can operate outside of the federal system. Technically, if someone was eating some gummy bears here in Illinois or smoking something or whatever, a federal agent could come in, someone from the FBI or whatever else, could arrest somebody in Illinois for violating a federal statute, even though they were operating under the state, by just if they caught them or whatever, like a cop. If you were caught smoking weed on the street and a cop came up, they could arrest you. Technically, a federal agent could do that. They don't do that. They don't apply or enforce that, because there are some realities of whether you want to enforce all that. Question?
How does the tax work? The state collects tax for weed?
So we didn't get into that conversation, but that is a really good question. I have no idea, because so I know some of the early states that adopted it do not have state income taxes. Colorado does have a state income tax that I believe. And so how does that work? I don't know. Do they literally drive bags of cash to the state? Like when I send my tax returns into Springfield, there's a place I send it to. I have an address, and I send my tax return there. I send a check to them. I don't know. They have to pay state income taxes in Colorado. And if it's cash basis, I don't know if they do. They may have. I just don't know. We could ask the First Bank of Weed. Maybe they process it for them. I don't know. Anyway, so that's, but as an example, just as a creative example, that's how state laws and federal laws can actually can be separate, but work independently. Question?
So when you talk about federal law and federal policing, but on the sheet you say federal local government, you say it's national law, not federal law. What's the connection?
Okay, so it's a good question. So when you work for the government, you are a federal employee. Okay, so that's why we call it's not federal. But national meaning it applies to the nation. It doesn't apply to the federal. There's not something like that. So that's why I call it a national law, meaning it applies to all states equally. It's enforced by the federal system, the federal agents and things like that, but it's a law of the land. It's a national law. Does that help? Okay, good. Okay, and then also as I say here, the states, so a law in Illinois doesn't apply to a law in Michigan. So, so if you have, if you're buying stuff here and you go over state lines, you may be in trouble. Like my friend, she would go and take these trips. She would go on these weekend getaways where they charter flights and they'd like a pub crawl. It would be like a shop crawl that they'd go around for a weekend and stuff. And then they would buy stuff, she and her husband, and they would figure out how to bring it home. And then they have to fly with it. And, if you fly, if there's going to be dogs, it's domestic, so they're really not going to be searching like customs do. But I don't know what she did, but technically, when she came home to Illinois, she had a bunch of illegal stuff. She had the little gummies and the little edibles and stuff like that. So the laws of Colorado don't apply to Illinois or to Texas or whatever. So all the states operate as their own little systems. Now, some states have reciprocity and comity between certain things, and they have agreements and otherwise. And in fact, in the profession of architecture, there are some states that honor your license from one state to the other. You don't have to take another exam. So these things happen. So it's not to say that every state works as their own little kingdom, their own little fiefdom. They understand that they are in this national U.S. country, and there are reasons for commerce things and otherwise that have share laws or have the same understandings as laws. But you can have laws in one state that have nothing to do with the other. Why is that relevant to what we're talking about here? Well, if you're doing and working on a project in Texas, Texas has very specific mechanics lien laws. Mechanics liens, probably maybe you guys, a couple of people might know what it is. Mechanics lien is if you do work on a project that improves the project, you can put a lien on the property, you can put a cloud on the title that takes a super right over, even over the mortgage, to make sure you get paid so the owner doesn't take your benefit. Texas lien laws are different than Illinois or Ohio or what have you. So let's say you're an architect practicing in Chicago, but you have a client that wants to build a building in Texas. When you write your contract, you may want to write into your contract, I want to use the laws of Illinois because they're more favored to you for whatever reason. Or I want to use the laws of Ohio or wherever it is. And that's because how they interpret it, the case law. You can contractually dictate what law you want to use because of our system that says these states work independently. Now, that always is a negotiation, and the guy from Texas is like, no, this project's here, we use Texas law. There's lots of things that come into that, but you can if you are able to. And I have litigated cases. I litigated a case in Michigan for a $3.5 million log cabin, if you can imagine, that was Ohio law. So we were in court in Michigan, the house was in Michigan, the problems were in Michigan, but the builder was Ohio, the owner didn't go to a lawyer first, and so we had to use Ohio law using Michigan judges. I'm like, I don't know what the Ohio law is, so we had to give them all the law, and then they had to interpret it like they were Ohio judges, because that's what the contract said. Okay, and then municipal, much smaller level, but those are your codes and zoning, like when you build in the city of Chicago, you got to build in the Chicago code. There's all these other codes that come into play, but you still have to follow the building code in Chicago, or in Glenview, or in Western Springs, or whatever. The municipal rules. You have to make sure you follow what the code inspector is. And so there's these smaller local laws that come in and they control things. Question?
Are those technically laws of guidelines?
So we have a slide coming up on that. So the answer is kind of. I mean, you need to follow them, but there may be codes that are.
Some bigger editions will have like 2009 IDC, and then you'll have like 2018 IDC.
Correct. So here's the thing. You can have a law, and I don't know if we have a slide today or not, but there's laws. Let me see what's next here. Yes, look at that right there. This is what I was going to see. Some laws are criminal, and some laws are civil. So codes and stuff would fall into the civil. So if you violate that law, they're not sending you to jail. It's not like you committed a crime. However, it may have a monetary implication on you. If you don't follow the local building code and your building falls down, they're not going to send you to jail because of that, but the lawyer on the other side is going to waive this and say he violated this code. He should have because he's building in the city. Pay me money for my damages. So it's a law, it's a code, it's an ordinance. They have implications and ramifications to how you practice. So, criminal law. Criminal law is designed to protect the state. Because as an overall, we want to have organization. The state wants to have people doing what they're supposed to be doing and following the rules, not speeding through traffic lights and robbing banks and everything else. It's overall to protect the state. But the state's interest is to protect the people, kind of like the federal government is to protect the people, like the Constitution is to protect the people. The ultimate role here, state to protect the people. We have, many countries do not, we have a jury system. And the jury system, whether you want to call them 12 cantaloupes in a box or not, the jury system is something that was unique. And it came out of the fact that the monarchy used to say, off with your head, thumbs up, thumbs down in Rome, whatever it was. And we decided we needed to do something, so we created in our Constitution that everybody's able to have a jury of peers. It's in the article, it's in the amendments. So you are allowed to have that. It was unique at the time. Nobody did that. Now, there are different countries that have different jury systems. Does anybody remember the trial of, I can't remember his name. He was the sprinter that had the carbon fiber legs, and he was tried for murdering his girlfriend. What was the name? Oscar. Yeah. So he was tried in South Africa, and they have a system where he can be found not guilty and then tried again. Like here, you get one bite at the apple. If you're not guilty, we have, So you can't have double jeopardy. You can't be tried for the same crime twice. But other countries have taken the jury system but subverted it a little bit because their constitution has allowed that. And so he was found, Amanda Knox in Italy, the one that the college student that was, she and her boyfriend were accused of murdering the guy, and she's from Seattle, and they tried to not export her, extradite her. So she was back. She will never go back to Italy, but she was tried 3 times there, and she was never there. And so she was found not guilty at least once or twice of those times, but ultimately she was found guilty, and then it was overturned. So different countries do different things. Our system is a jury system. You're either found guilty or not. If you're found guilty, there's a whole bunch of appeal process. If you're found not guilty, no double jeopardy, you're done. So that's kind of unique about it. So that's the criminal law. I have a little note. What's really a jury of peers? And that's, who knows really what that really means. Anybody here serve jury duty, or at least try to go to jury duty? So did you get on the jury?
No.
Did you get on? Yeah, same with me. I actually probably will never serve on a jury because you get in the box and they start asking you questions and everything. And you're like, what do you do? I'm like, I'm a lawyer. They're like, we don't want a lawyer in there because you're going to be questioning how we do. And if we don't do it right, you're going to be telling everybody in the box, and they're all going to be looking at you because you know all this stuff, and you will be the only one making the decision in the room. So lawyers are rarely put on it. So I never have. My wife's been on a couple times. My mom's been on a couple times. But were they the peers of the person that was being criminally charged? Absolutely not. My wife had nothing to do with the gentleman that was being charged for the crime that he was being charged. But it's an imperfect system, but we do the best we can. So, civil. So the civil law is built to balance interests between groups and individuals. Okay? So, and it may be not necessarily between groups and individuals, but there can be balancing of interests of groups, balancing interests of individuals, balancing of interests of society as a whole. We want to make sure that a doctor follows the rules and professionally responsible the way they treat someone, because as a whole we want to protect society and people that they practice professionally and responsibly and don't commit malpractice. In that individual that may have been injured by the doctor, we also want to protect, so we give that individual a right of recovery. If you are injured or damaged by someone, a tort, you can bring a civil suit for monetary recovery. Because how else can you get someone can you compensate someone other than potentially monetary recovery? In our profession, that world often comes into the worker that falls off a building, the wall that falls down on someone, a leg off, an arm off, a closed head injury. Those types of things are torts, and they have monetary recovery for those types of things in torts. Or the property is damaged. No one's injured, but something has happened to damage someone's property, and you recover for that. So that's a civil. Or we have an agreement. I'm a contractor. I promise you, owner, I will build this house for you for $1 million. I screw it up along the way, and I tell you got to pay me $1.5 million. You're like, no, you promised you'd do it for $1 million. Then I'm like, find somebody to finish it because it's going to cost me $1.5 million. If you go out and have to spend $1.7 million and you spend somebody else, the guy that promised you to do it for $1 million owes you $700,000 because it's simple math. We had a deal. You build this house for me for $1 million. We had no changes. Cost me $1.7 million. You owe me $700,000 because you promised you'd do it for me for $1 million. I mean, that's the very basic, but that's civil suit. You bring a civil suit for me because it cost me $700,000 more than you promised me. It's a civil promise. So that's part of what civil, protecting interests. Part of civil law is built to create predictability. You want to enter into a contract and have the words and the language that says, if I say I will do this, then I can predict that that's what you're going to do. People want to understand that what's happening next, even though it's in the future, we all expect these things to happen. So that's about, and civil laws to create that for those types of things, so people can understand what's going to happen next. As a, criminal law, you can't run a red light, but you may have some civil laws of how you need to act and civil laws are created by the court system is how does it impact people's daily lives and what they do. You could have statutes that create civil law, and you can have ordinances. So like you can have common law. So your question on like an ordinance or a code, those are not criminal laws. They're civil laws that govern a builder or an architect or a doctor or what have you. They govern, and they can be statutorily written. They can write out a building code. In this wind load, you need to have this one. In this snow load, you need to have that. It's written down in black and white. You can also have common law. Common law is cases. Someone comes in and says, we have this handshake. It's nothing written down. Or we have this contract. It's written down, but it's not governed by a code. It's not governed by something statute or whatever written. It's just, what do architects commonly do in this situation? What is the industry standard? 4 out of 5 dentist surveys say you're supposed to do this. And then you go to court to say, and you get your 4 out of 5 dentists on the stand, and they say this is what they should have done, and the judge renders a decision. Now you have a ruling that both parties must abide by, and that is what's called common law. It's never written in statute, it's never created by the legislature, but that case law becomes the law for that set of facts. And then what ends up happening is when the next set of facts comes up, instead of 4 out of 5 dentists, it's 4 out of 5 accountants, and the lawyer representing the accountant takes that case and says, this is what they did when 4 out of 5 dentists said X. So don't you think 4 out of 5 accountants saying that's what an accountant should have done? Don't you think we can use the ruling of the court of why those 4 dentists were important to say why these 4 accountants were important? So now you have 2 different professions, 2 different sets of facts, but the common law is the same of how the outcome is. It creates predictability. Does that make sense? Okay. We also, in the civil system, we use the jury system, but you are not required to use the jury system. In fact, some contracts negotiate specifically not to have a jury trial, and that's an agreement between the parties. Sometimes it's silent in the contract, and when you file your lawsuit, if you fail to ask for a jury trial right in the beginning, you've waived it. So on the civil side, you can have what's called, has anybody here heard of what's called a bench trial? So you know a bench trial? So bench trial is the judge, because they sit way up on the bench. That's why it's called a bench trial. And the judge listens to all the facts and makes the rulings, overrule the objection, I'll let that evidence in, counsel sit down and shut up, whatever the judge is going to do throughout the trial. And then the trial, the judge listens to all and he renders a decision. That's a bench trial. With a jury trial, there's the 12 cantaloupes in the box, no disrespect to any of them, and the judge goes overruled, counsel sit down and shut up, does all those other things, but when it comes time to the decision, the judge goes, jury, you've heard all the evidence. Here's a bunch of rules you must follow that I put together, and with the 2 attorneys, we all came up with these rules. Follow those rules, fill out the boxes on the sheets that I give you, and you give me the decision. And then all the judge does is read it. So that's the 2 difference between the judge and jury system. Criminal, you are always entitled to a jury. So you're not going to have a bench trial with a criminal system. You may not have 12 people. You may have only 6 in a jury sometimes in a criminal, but most of the time you're going to have 12 in a criminal case. You can decide to have 6 people in a civil trial if you want. You can decide we're going to have a jury of 6 or a jury of 12. Or maybe you have something different. Normally it's 6 and if you're going to be doing the jury. So that's on the civil side. Any questions on this so far? Good. Okay. Hierarchy of laws. There will be at least one question on this. I think there's one on each exam. So star this page when you get the question that says, which of these are in the proper order of hierarchy in the exam? Find this page in your notes and get this question right. Sometimes people don't do that. And I say the same thing every year. There's going to be a question of hierarchy. Find this page. This is an easy one, okay? But I'll walk through you. So at the top, and I'll talk a little bit about this kind of getting here when we're doing where the cut is the Constitution. The Constitution is the law of the land over everything. So you can have a state law, and here's an interesting thing when we're going back to this cannabis thing, is we have a federal law that says you can't have marijuana. It's a federal law that's derived from the U.S. Constitution that allows the power of the federal government to ban cannabis. Now you have state laws that allow cannabis. How does that happen? If the federal law allows an act that says you can ban cannabis and it's illegal, how can a state law be in consistency with that? Well, it's because the Constitution does not say cannabis is banned. What has happened is the federal people created a statute, a law that says cannabis is illegal because of the powers that the Constitution allows you to have. Those same powers give the states the right to create a law that allows it to be legal. And that same power, if ever it happens, could allow the federal government to legalize marijuana. How do we know that? Prohibition. Prohibition back in the 1920s, alcohol was legal before that, and they created a law that said all alcohol was illegal. That was a national law, and the U.S. Constitution supported it because it gave powers to regulate and create laws banning things of commerce. Commerce meaning the sale of alcohol. And so prohibition in that federal law was legal. And then there was all these people doing moonshine and people dying because of bad moonshine and all this other stuff and the revenue and the costs and then all the money that should have been flowing for taxes and all the politics that were behind the scenes. They got rid of prohibition and they used the same power under the U.S. Constitution, the Commerce Clause, to say alcohol is legal. And they can regulate everything else. So that's how you can have a state law that says cannabis is illegal or legal and a federal law that says it's not legal. But it's all governed by the powers of the Constitution. Question? Same-sex marriage was statutorily in states. Then those statutes were challenged as being unconstitutional, and that went to the United States Supreme Court. And the United States Supreme Court created a law, because it's the U.S. court, that said that law is legal and it's constitutional. So whether other states have adopted that law or not, we now have a federal statute that applies to the whole, or federal law, common law, not a statute, that applies to the whole country that says same-sex marriage is legal under common law. Certain states still statutorily say in the books it's legal, but as a common law all over. There are some strange, there are laws in some states on things like bestiality that are still on the books. Because, now, whether they're enforced or not, I don't know, but there are bizarre laws that exist in books across the state, because whether they haven't been challenged as constitutionally or not, there may be an overriding law of the U.S. of the federal Supreme Court that says it doesn't matter. I mean, that's one of the things that, again, not trying to get political or anything, but the people that are trying to create these statutes that are trying to change the third trimester language of Roe v. Wade. And they're trying to do all these different things about it to change what that is state by state. And they're trying to see, will I be able to get this little narrow interpretation of the constitutionality of this law and still stand consistent with the language, the big umbrella language of Roe v. Wade. And that's not just Roe v. Wade. There's other laws that get what they call being chipped away. Because when one law, the world of common law is, as I kind of made this example of 4 out of 5 dentists and 4 out of 5 accountants, is you take a law of these facts and it has this big umbrella, you apply it to a case similar but not exact, and maybe it takes a little piece of that away, or sometimes it adds to that, makes the umbrella bigger. That's just kind of the nature of our system. So, did you have a question too? I'm sorry. Okay. All right, so Constitution applies to everything. Next thing down, statute. Statute is something written by the legislature, whether it's on in this case, we would say it's a federal level, but you can have statutes at federal, state, and county and city. The county and city are going to be codes and ordinances. Your state and statutes can be criminal and they can be civil. So a statute is something that the legislature, the congressmen, the Senate, they put together, they write up a law, and that's why they're called lawmakers, because they make these statutes. So, highest Constitution. Next is statutory. If it's a federal statute, it applies to everybody. If it's a state statute, it just applies to your state, and so forth and so on. After that, executive order. Now, when I first started teaching this thing, nobody ever heard of an executive order. Like, what does that mean? And I'm like, well, that comes from being king. Way back when, that was the top. There was no statute or constitution. The monarchy started at the executive order. And that's what it is. It's the person that's in the seat of the power of whatever government, whether it's the United States president, whether it's a governor, whether it's a mayor, whether it's the local city commissioner, whatever it is, they can write an order that says X. But understand that if it's in violation of a statute or the Constitution, that executive order has no power or is not enforceable. Then we get into our tripartite system and everything of whether people will actually enforce that executive order, whether it's going to be challenged and otherwise, and that's a different argument and everything else. But in the hierarchy, executive order comes below the Constitution and the statute. Okay? Administrative order. It's part legislative, part executive. So the executive branch is your mayor, your governor, your presidents, your local city councilmen. Those are that's your executive side. The legislative is your congressman or your elected officials. And so sometimes you're going to have an administrative order where what happens is the legislature creates power so that an administrator can then issue an order. How's that applicable to you guys? So when you guys take your licensing exam, you will be regulated by the Illinois Department of Professional Regulations. So there is a governing body in there. They are going to govern and see whether you are acting professionally responsible, and they have a series of administrative orders that they can impose on you. That body, the Illinois Department of Professional Regulations, whatever that acronym is, they are created because the legislature created that body. They said, we don't want to have to do all the laws, so we're going to use our power to create these various administrative bodies, and they're going to govern their own people. So the doctors govern themselves, and the lawyers govern themselves, and the architects govern themselves, all because the legislature gave you that power. So that's this administrative order that has its basis in legislative, but it's administrated by the executive side. Underneath that, common law. That's what we've been talking about. It's law that made by the court. So any one of the top four above that, 1 through 4, can trump or override what a court says. And sometimes you're going to have a court that's going to rule one way, a series of facts, and the judge rules this way. If you can come back in one of your appeals, say, this is in violation of the Constitution, this statute, this executive order or administrative rule, and the judge was wrong, you have an ability to overrule that common law because it's fifth in the hierarchy. Question?
When somebody challenges an executive order,
Mm-hmm.
When
they're challenging the executive order, they're using it's in violation of the statute, which is legislatively created, or it's in violation of the Constitution. You literally just have to take a look at this list and say, if I want to challenge a ruling, go up. If you have a ruling at the top, it's going to probably be, the Constitution is going to be created, like, the Constitution is not, can you imagine how long the Constitution would be if it had every single law of every land? It would be huge. So the Constitution gives these powers to create statutes, or to create administrative orders, or to create legislative. So each one and what they create is the powers of how they're enforced or how they're put on the books or whatever, it goes down. If you want to overrule one, you go up. That's why we have it listed in a hierarchy. Okay? Next after common law is contracts. The parties can agree. We can agree to do whatever we want. Basically. Almost. Not quite. So like my example of this thing called mechanics liens, and we'll talk about those later, I'm not going to get into depth of it. You can only have a mechanics lien in the state where the property is located. So I can say that all this contract is going to be enforced. The project's in Texas. We're going to use Illinois law, and I can put that all in there, except mechanics lien. Because mechanics lien is a statute for the state of Texas, and it's applicable to that area. And so that overrides, because it's a statute, it's above contract law. But contract law is an agreement. There's no law in Texas that says you must always use Texas law for everything that goes on in Texas. Just certain little things. So I can have an agreement through a contract. We're going to get in this contract, we're going to use Texas law. Okay? And the last one here is custom and practice. What do 4 out of 5 architects do? What do 4 out of 5 dentists do? That's the custom and practice, and that is how it's applied. Like, no matter how, my 300-page contract still isn't going to cover everything. So I have a provision in all my contract that says the architect is going to perform in accordance with industry standards. And that's custom and practice. Okay? Any questions on that?
Yeah.
Yes.
Architecture is an international profession.
Yes.
So when we build internationally, like some of us are doing a design studio that's happening in Montreal.
Mm-hmm.
Like the licensing and the laws that they have to obey, are they just based on Canada law then?
Yep. Yeah, there's going to be whatever national laws that apply to Canada and whatever legislative laws that are created underneath that. And then ultimately you're going to have your local zoning codes in Montreal, and you're going to have to follow those things. I mean, even think about it this way. Forget international. Like if you're building something in California, you got to go with building codes for earthquakes. If you're going to be building something in northern Minnesota, you got to make sure you're applying for snow loads that you're not going to be dealing with in New Mexico. Question?
For states like you do your license in Illinois, you do reciprocity in Wisconsin,
Yeah.
or Indiana. How does that work internationally?
So it depends on what for the same reason why each state can make their own rules, each country can make their own rules. Most of the time, international, there's a certain boards that you have to go through, and they may recognize, but it's not always. Like right now, my soon-to-be former firm, we are looking at a project to be built in Saudi Arabia. And one of the things is we are doing a study right now of whether, A, we want to use Saudi Arabia. We're going to have to build by their codes, but whether we want to use Saudi Arabian law, whether we want to use British law because the architect's from England, whether we want to use U.S. laws and AIA contracts. So we're going through all that study to see because, you may end up having a British contract and a British law and everything is fine, and then it's being adjudicated by the king and those people down there because it's a kingdom, it's a monarchy. And so what are the benefits for it? So sometimes it's not even just reciprocity. Sometimes there's a political reason why you want to do it. Sometimes there's a geographical, like I said, snow loads or wind loads or Canada, whatever you're going to do. So there's all these factors. And you can't answer it's definitely this way for anyone otherwise. Like you said, you're going to have reciprocity. If you practice architecture in Illinois for a certain number of years, you'll have reciprocity in Wisconsin. I think Michigan, it depends on what state. Sometimes it's 5 out of 7, sometimes it's 7 out of 10, whatever it might be. You're never going to get reciprocity in Florida. You're never going to get reciprocity in Arizona. Why? Is the law different? It's not California. No. The reason why is those laws said we're tired of retiring architects coming here, opening a shop, and taking away business from the people that are born and raised here. So we're going to make, if you want to practice in Arizona, you have to sit for your exam here. License as a lawyer, as an architect, as a doctor. We're going to make it just a little bit harder so you don't take business away from it. Sometimes it's a business decision of what happens in reciprocity.
When so the British architect.
Yeah.
Do they have a partner with somebody in Saudi Arabia as an architect to get the stamp?
It depends on, to get it sealed for the local building codes, yeah, they'll have to have a local office, or they either have their own local office, and I can't remember if this architect does, because we're just kind of brand new and looking at it. The project isn't 100% going. But yes, you'll do that, or you'll hire someone to work as a joint venture, so they're tandem with that. So there's all different ways to do that. So, and that happens like with Navy Pier. The design team was 14 firms from all over the country, and actually a couple of them from Europe. And so we had various different agencies handling it. We had 3 local architects that were the sealers of everything, architects and engineers that signed and sealed everything. But and we'll have lectures, one lecture later on this about how much that they actually have to be a part of the design. You can't. It used to be you could just seal it. You would send it to someone in Illinois. Here's $5,000. They would seal it and move it on. Now there actually are not tests, but levels of involvement. You have to show that the person that's sealing it really was a part of the process, so it's not just, a rubber stamp type thing. So, okay, claims. We'll talk about claims, and then we're going to talk about the case. What is a claim? Claim. Okay. Because there are claims, we need these laws. A claim can be both civil and criminal, because we're doing the civil and criminal. Criminal. They assaulted me. They kidnapped me. They robbed me. That's a claim. Somebody's making a claim that someone did against them. Civil, same thing. They ran a red light and hit me. That would be both a criminal claim by the state and a civil claim by the person that was injured. The wall fell down on me. They promised to build me the house for $1 million. It cost me $1.2 million. Those are all claims. I am making a claim against someone else. So we will mostly explore in this class civil claims because it's relevant to the practice of architecture. I don't know. I have never handled a case where an architect has been charged with a criminal crime in relationship to their profession. I'm sure there have been. Just like doctors, like the doctor that handled all the really terrible situation with the U.S. women's gymnastics team. He committed crimes. So that's criminal, and then he also committed, the minor thing that happened to him is they took his medical license away, but that was a civil component of it. And they are suing him or whatever money he made and Michigan State and other people for the civil side of it for monetary. So, and you can have criminal and civil at the same time. But we will mostly talk about civil stuff in here. The most important relevant for you guys are claims against design professionals. You guys committed malpractice. I mean, we all have heard malpractice. Mostly you hear about it as doctors, lawyers. We don't commit malpractice, do we? Occasionally accountants. But you can be because you are a professional, because you are licensed, because there are public policies that are governing what you can be sued for malpractice as a design professional. A claim against you. Claims against owners. I'm an architect. We entered into a contract. I was going to design a building for me. You were going to pay me $100,000. You paid me $50,000. You owe me money. I'm making a claim against you as an owner or a contractor. I was going to build this building for you for $1 million. When I started digging the basement foundation, we thought it was going to be this type of soil. Instead, it was muck and goop. I had to spend another $200,000 just to be able to get the hole dug to pour the concrete. So while I told you I could build it for $1 million, it costs $1.2 million, but you owe me $1.2 million because nobody told me about the goop in the ground. Had I known, I would have bid $1.2 million. So you owe that to me. That's a claim against an owner. And this is very high level, but that's how that works. It's not the contractor's fault. Now, if the contractor knew the goop was there, had soil samples and a whole bunch of other stuff, it's a different animal. But if it's unknown, question. That would be a change order. Now, interestingly enough, that would be a change order that the contractor would submit. It said, I dug this hole. All the information you gave to me did not tell me that there was going to be this in the soils, and I didn't bid it. But I have to dig the hole, and I have to be able to build this. It's going to cost me the $200,000. Here's my change order for $200,000. And then the architect's going to look at it, and the owner's going to look at it, and they're going to say, we agree, or it should have been $150. There may be discrepancy in the price or some of the scope. There's all different things that come into it. But the goal is to try to get them to approve the change order. So really what you have is the contractor submits what's called a change order request, or a COR, and then when it's signed off by everybody, it becomes a change order, and it's a change order to the contract, and now it's a $1.2 million project, and that's what needs to be paid. If you're not paid, you have a claim. Or claims against contractors. And claims against contractors can be the same thing. The owner says you're going to build a house for me, nothing changed, you build it, it's cost too much. Or the wall fell down because you built it crappy, I have a claim against you. So it may be monetary, it may be for tort, there's all different types of things. Okay, make sense? Question?
So if you're a builder who draft something under bid, you can pretty much sue for more than you were paid.
See, now you're way down in the semester. So that's what's called a claims contractor. So here's a little nutshell. Now we get into business. Now we get into hedging our bets. So you have contractors out there that will lowball bids, but they'll be close. Because, as I said earlier when I asked everybody, do you know what a change order is? I said, every single project has change orders. And so some contractors, and they are known in the industry, are what's called claims contractors. And what they do is they hedge. If I can get this job, let's say it's a $10 million job, and that's what the architect says it's going to cost and everything else. And so your bids are going to come in between $9.5 million and $11 million. So there's going to be this kind of sway. And this guy comes in at $9 million. Okay? What that contractor is going to do is he knows if he really did the math right, if he really bid it properly, he knows it's going to be about 10.4. So somewhere he's got to make up $1.4 million. And so what he's going to do is he's going to immediately start writing letters. This is not what the drawings say. This is not what the site is. And it's always going to be, they did something, they did something. And if there's a legitimate change, they're going to push it a little bit further. Instead of $150,000, they're going to say it's about $175,000. And then you're going to get into these discussions. This is the honest truth. This is the underside, and you'll see this when you get out in the real world. This is the reality. This is why they call me. Is if I'm a contractor and I say, pay me $175,000 for this work that legitimately needs to be done, and the architect looks at it and runs their math, because the architect is kind of like the owner's cop. The architect says, you know what, it really is probably about $125,000, maybe $150,000, but somewhere in that range, no way $175,000. It's a $10 million project. We're talking about a $25,000 delta between the $150,000 and $175,000. And the contractor is going to make a bet. He's going to say, I bet I can get $165,000 out of this guy, get $165,000 out of him. It's going to cost me $130,000 because they don't want to litigate. They don't want to get into this. And you get $15,000 here, and you get $20,000 here, or depending on the magnitude of the project. And the next thing you know, he's got his $1.4 million, and the project that he bid and he got for $900,000, $9 million, he gets his 10.4 when he's done. And he makes the profit, and he gets the job. And there are people that are experts at this. There are companies that do this. They know just where to push, and they're known as claims contractors. Keeps me very busy. And it makes a lot of owners unhappy. A lot of times it happens with one-time owners, like not a sophisticated owner that is in the process of building and building and building and doing part of their whole industry as expansion or whatever. But like we had a project with one of my partners handled it. It was like the sisters of so-and-so and so-and-so, and they're building a library. Like they had taken all the little collections for all these years, and they were going to build one building in their whole lifetime, but there's a bunch of nuns. And they got taken to cleaners by these claims contractors. And so yes, that can happen. And that's part of the reality of things like that is sometimes people will push the system. Sometimes they'll work that angle. And do you want to spend the money on litigation or not? So, okay. And I'll have lots of examples of that throughout the semester. Okay, so what's a claim and how is it resolved? Now we're going to get into the elements of a claim. And we're going to use here's what a tort is. I told you we'd get there. Now you can write it down what a tort is. So they're going to have two things. Contract claims come in two categories of civil claims. Tort and contract. So what makes up a tort? A tort is an injury. Some type of an injury. It can be injury to personal or property. So it doesn't have to be you. Like, if you get in a car accident and you're not hurt, but your car's smashed, that's a tort because it's an injury to it's a damage or an injury. Injury kind of is damage. It's that same type of term. It's not necessarily physical injury to property. Or a building fall down on like let's say you're building in Chicago, really close, a brownstone, and you're building and something happens to the next door neighbors. One of my clients, they had a rental apartment, a rental condo that they had. This woman was developing a building right next door. She didn't grade the property right while they were under construction. Torrential rains, it flooded his entire basement unit. So the people who were in there had to move out for 3 weeks. He had to put them up in a hotel. He had to pay for all the water to get out. He had to redo his things like that. That was a tort because water came from one side to the other. And we went through this process of whether it was worth it for the lawsuit. He had about $40,000 in losses. But I told him, if you want to litigate this, and the developer on the other side, she was playing tough as nails because she's been sued more than once. I looked up her history, and she's kind of gone through the system. She knows what she's doing. We opted not to sue. He said, and I gave him names of people that were less expensive than me, but very competent and things like that. And I said, but it's still going to cost, you want to take this to the max, it's going to cost you $60, $70, $80, $100,000 when you're done to recover 30. How do you want to deal with this? So he fixed his basement, moved his tenants in, and sold the building. So that's a tort of property. So you can have tort personal and tort to property. Contract. What makes a contract? We're going to talk about the elements of a contract later on. But a contract claim is, on the very basic levels, I made a promise to you, you didn't live up to your promise, and as a result of failing to live up to your promise, I am damaged. It costs me money or time, and time has value, monetarily. So I'm going to bring a breach of contract claim. You broke your promise, pay me my damages. And tort, same thing. You injured me, you injured my property, you damaged my property, pay me my damages. That's how that works. Does that all make sense? Okay, second element of a claim, or the big elements, is there a duty? Do you have an obligation? So by the pure nature, simple one is contract. I wrote down or we shook hands. I promise to do this if you do that. I promise to design you a building if you pay me $30,000. You have created duties and obligations to each other. If you don't design it completely, I don't have to pay you $30. If you design half of it, I only have to pay you $15 or maybe less depending on what the value of that is. So it's that for a claim, there has to be a duty. If there's no duty, no claim. And sometimes you get into it in a contract side, and somebody says, they're supposed to do A, B, and C, and the contract says, no, they were supposed to do A, B, and D. And if you think you have a claim on C, you don't, because they owed you no duty on that, and you can't recover damages. So it has to be in a contract. You have to be able to understand what the promises were. Civil for a tort, it's not going to be in writing, but there are statutes, codes, industry standards. And so the person walking down the street expects that the building they walk into was built in accordance with the codes. And so you owe a duty to the general public to follow those rules as a professional responsibility to follow those codes. So when someone is injured, even though you have no contract with them, a complete stranger, if you violated your duty to the public, that means you violated your duty to that individual. So here's a perfect example that I talk about at this time of year, always in Chicago. If you have a public place of business, you are not obligated when snow and ice comes to shovel your walk or to clear the ice. That's nature. You have no obligation. So if you never shovel and you never clear, and somebody walks into your building and they slip and fall on nature, you can't be held liable. Now I'm talking a very high level. But if you lay down some of the melt, or you shovel it and you don't shovel it properly, and then ice forms from your action, and you didn't do it safely, and someone slips there, you have breached your duty to the public in large because you didn't make it properly safe. When you took an action and you violated your public duty, then you are liable for that. Another example is the Good Samaritan law. Everybody ever heard of the concept of the Good Samaritan law? That's the thing that says if someone's ailing on the street and a doctor goes down to help them, the Good Samaritan, the doctor's not held liable. That's what everybody thinks the Good Samaritan law is. That's actually not true, because the doctor's a professional and the doctor is acting in their capacity as a professional. If I, the lawyer, went down and gave CPR and administered help to the person having a heart attack because I am not a professional, that's the Good Samaritan. So I'm not held to professional standard. I owed no duty to them. If I gave them legal advice and it was wrong, I would have violated my legal obligations there. So I have no duty to the person helping. That's the Good Samaritan law protects me. But a physician owes a duty because of its profession to everyone. So the moral of the story is, don't fall down on the street near a doctor. Make sure it's just a normal person and they'll help you out. Because the doctors might not help you. under that rule. They probably will, but that's the concept of a duty that's owed to a stranger. Okay? Next element. There's a breach of that duty. I promised you this. I failed to deliver. I breached that duty. Contract. Simple. Or as I gave an example, the doctor had a duty and didn't perform properly. They could have breached that duty. Or you as an architect, you didn't design that building in accordance with the codes and it fell down. You've breached that duty. You didn't properly shovel the snow. You've breached that duty. So the common law, the public interest, statutes and codes create the duty, and a claim comes because you breached that duty. Make sense? Going on. Causation. You have to say that there is a causal link between the injury and the breach of duty. So, if I improperly shoveled everywhere but where the slip happened, and I didn't shovel that area, did I breach a duty? I may have breached a duty and created ice everywhere else, but where I didn't shovel, if that was the issue, was the act that I did it cause that injury? Or in my design of architecture, I may have designed the building improperly and the wall fell down, but did it fall down because of my design, or did it fall down because the contractor built it incorrectly? And no matter what I did, the wall was going to fall down because the contractor used improper materials or shoddy workmanship. Was I the cause of the injury? And that's a lot of area in the law where because we live in America, you sue everybody, is you try to figure out, and everybody points fingers, so they caused this, or they caused this. And ultimately, it's up to the judge or jury, and many times, when you get to the end of the day, to apportion. Well, we're not sure exactly, but maybe the architect had like 20% fault, and the contractor had 70% fault, and the owner had the remaining 10%. So there's this apportionment of who's obligated and responsible for that. But the question is, did your breach of duty cause the injury? And that's always a question of law in a claim. And then finally, are there damages? Sometimes you may have a duty, you may have breached the duty, you may have caused the injury or what have you, but there was no damages. So in a contract case, maybe you're going to say, you promised me that I would have my factory opened on August 1st, and I had to open August 15th. You failed to deliver on time. We had a contract, you had a promise, you breached that promise, and it was the cause of the factory opening 15 days late. But I didn't miss one sale. I didn't have any rent because I had my rent already locked up for the other place. I was going to go through September anyway. I built in all these things. I have no recoverable damages. So my defense, I may say, you know what, you're right, I'm guilty on all those things, but it didn't cost you a dime. You have no claim, we're not going to court. And that sometimes happens. Sometimes people don't have monetary recoverable damages, even though there's a duty of breach cause and an injury. So, that's the final element of that. So you get all those elements: duty, breach of duty, causation, damages. You now have a recoverable claim. What do you do? How do you get it resolved? And so what I have is the old school. Kind of fight it out, you duke it out, the king says this and this, or you have the legal methods, and that's litigation, or we'll talk about mediation, arbitration. Okay? Any questions where we are so far? Good. Dispute resolution process. So we're going to try to go through these quicker, because I'm not going to get into on the exam, tell me how you have to go to court and this and that, but I just want to kind of give you an overview of what the court's on. And then I chatted a little bit and I was late, so we're a little longer than normal, and I apologize for that. Okay, so we have two areas of dispute resolution in the world. We have binding on one side and non-binding on the other. And binding is you got to follow. Whatever they say is that's the rule. So you have what's called litigation, which is a lawsuit. It's traditional. It's what everybody, it's what they did forever and ever and ever. It's expensive and time-consuming. The only person in not all, but many pieces of litigation, the person that makes out the best is the lawyer. Because it's expensive, it takes a long time, and we keep billing hours and billing hours and billing hours and everything else. But sometimes there's big recoveries, sometimes it's a big deal. Sometimes it affects the company, business, and everything else. If you don't want to go to court and you want to be a little less expensive or you want to have a little bit more freedom, a little more flexibility, there's what's called arbitration. And arbitration is only by agreement. So the contract you enter into has to say, before the dispute arises, we agree to go to arbitration. Sometimes after the dispute arises, you can both agree to say, let's forget the courts and we'll go to arbitration. But if you don't have it in writing and you go to them and say, let's arbitrate that, the other can say, nope. And I've done that. I've been in scenarios where it's to my benefit to stay in court. Claim was brought against my client. The other side came to me and said, do you want to arbitrate? I'm like, no, because it was going to be more expensive for them. So we were able to resolve the case faster and cheaper, in my opinion, because they saw that it was going to be 3 years for a verdict. And so sometimes time value money, the other side wants their money faster, so you get a result. So that's part of being a lawyer. That's part of negotiation strategies and everything else. So binding. Everything is a decision. So you're going to have a judge or jury in litigation or an arbiter in arbitration, and their decision is final. It is enforceable by law. Non-binding. Negotiation, you can just have people sit down and talk. It's always encouraged. But that's always limited to the people who are chatting it up, who are the lawyers, how well they know the game and what they want to do. I have a big case that I'm working on right now. I have spent 4 months trying to convince the other people that I really want to negotiate in a settlement. And one of the two other parties is all ready and I can get them to settle. I don't have numbers yet, but I know I will. The other one, he's using the same strategy I just used. He's like, nope, let's fight, because he knows that it's going to be expensive for my client because I'm the plaintiff. The other option is what's called mediation. Mediation is where you get an independent neutral, someone who has nothing to do with either side, has no power of a court, no power of an arbiter, but he or she is skilled in getting people to talk and will know what the industry is about and will give you a business decision. And sometimes it's written and reasoned and uses case law and basically says, I heard your side and I heard your side. And I think this case to side A is, I think you're entitled to $500,000. I know you're asking for $1.4 million, but I really think it's about $500,000. And I know you, B, only want to pay $200,000. But here's what's going to happen, and I'm going to give a reasoned opinion. If you take this to court, this is where it's going to come in. It may come in at $500,000, maybe come in at $800,000, but both of you guys are going to spend $300,000 or $400,000 in litigation. So I'm going to try to resolve this by a mediation, non-binding business resolution. I use this all the time. It's the most successful way to resolve a construction claim. Construction claims are very expensive, they take very long, and they're very boring. Juries just don't want to listen to you talk about lintels and whatever else there is. So, do you have a question? Yeah. It can be by mediation or it can be by negotiation. Sometimes you get to the courthouse steps and then the lawyers have settled the claim and that's settled out of court. But settled out of court means you never presented it to a fact finder, judge or jury, to tell you what the case is worth. You've come to a business decision with sometimes a neutral or on your own to come to a resolution. So. Okay, quickly, anatomy of a lawsuit. So you have a plaintiff. The plaintiff is the injured party, and they are going to file what's called a summons and a complaint. The summons is, you've been served. That's that piece of paper that gives you that says you've been served, here's your document. The complaint is the written facts of what happened. The biggest complaint we've heard in the news since July is the whistleblower complaint. They wrote down all the stuff that they heard about. That's a complaint. It's just the statement of the claim, and it will have duty, breach of duty, causation, damages. So it'll have all those things as a valid complaint. If they don't, I'm going to move to dismiss it. I'm going to say this complaint doesn't have all the elements. It's gone. Okay? So what do you want to do? Unless you're an individual in the state of Illinois, I think all states, if you're a corporation or any type of company, sole proprietorship and everything else, you got to hire a lawyer. It's by law. You can represent yourself personally on an individual claim, but anything else in the business world, you have to hire a lawyer. Pro se is the next thing. That's what I talked about is an individual. You file an appearance, meaning the lawyer comes in and says, I'm Mike Hanahan. I'm appearing on behalf of Jane Doe for this lawsuit. I represent Jane Doe. That's an appearance. I've appeared in front of court. And then there's the process of serving everybody else. So that's the complaint, making sure everybody that's going to be a party to this lawsuit has been served by summons. Okay? The defendant is the person that's being sued in court. What do they do when they get this complaint? They read it and they're like, oh, what do I do? Well, they have to also get a lawyer to file an appearance. So they get, I, Mike Hanahan, I represent John Smith. In this lawsuit, we're being sued by Jane Doe. I have read this complaint. It does not have all the elements. It has duty, it has causation, it has damages, but there's no allegation of a breach of duty. I'm going to move to dismiss the complaint. We've all heard, well, I don't know how much you guys have heard, but they talk about on Monday or Tuesday, whatever it is, are they going to move to dismiss the articles of impeachment because they say it doesn't have all the elements of the claim? That will be a legal strategy for dismissal. So the defendant can move to dismiss. In every type of action, criminal, civil, whatever it is, you can move to dismiss because the complaint that's been filed fails to satisfy all of the elements. You can answer the complaint. I read it, it's got all the elements, but yes, you got my name right. Yes, you got where I live right, but I deny. I don't think any things are true. I don't agree with you, or the way you said it may not be true, or whatever, so I deny it all. That's an answer. You file that, and now you're on file as answering the complaint. You can also say affirmative defense, going back in the construction thing. Yes, I'm the contractor. The owner's suing me because they had to spend another $300,000 on this house. But I have an affirmative defense. The owner failed to tell me this. So I have a defense that they affirmatively had a duty. They affirmatively breached that duty. And so I am not liable for that additional $300,000. And in addition to that, I have a counterclaim. They owe me $200,000 because not only did they fail to do this, this, and this, but they had these change orders and they didn't pay me on that. So I don't owe them $300. They owe me $200. That's a counterclaim. So the defense is, I don't owe the $300. The counterclaim is they owe me. And in the counterclaim, I have to have all my elements. We had a duty, a breach of duty by them, causation, damages. So my counterclaim is effectively writing my own complaint going back against them. Make sense? Okay. Next, pretrial discovery. That's this exchange of documents. Okay, I want all of your documents. I want all your witnesses. I want to see. I'm going to read all this. I'm going to have written interrogatories. You're going to give me all the information you have, every email under the sun, every video recording, everything you have that's relevant to this lawsuit. The purpose of it is to make sure that everybody understands is on a fair playing field. So we all are working with the same set of facts. And it's probably the most expensive and time-consuming part of a case. We had a case last fall that was about an $18 million case. It had to do with welding of various pieces of steel. It was lots of the process was very new. My client or our client probably underbid it, but the owner didn't really tell them enough of the things. So we were suing for about $18 million. The discovery was 600 gigabytes of information. 600, millions of pages of documents. And you have to go through them all. You have to read them all. You have to figure out what's relevant and not relevant. You have to figure out what's the key documents and everything else. 600 gigabytes. So that's what happens during this thing. It takes the most period of time, the length of time it takes. That's why a case lasts 3 years, because 2.5 years you're in this discovery phase of trying to figure all these things going back and forth. And then there's motions. I don't want to give them this information. I don't want to give them that. There's all this back and forth of saying motion to dismiss, motion to strike, motion to compel. I had a case where, very small case, it was about $150,000. It was an interior apartment one. And all we did was ask for the architect for their records, because not only was she designing the space, but she was purchasing all the furniture. And she had said she was getting us the merchandise mart discount, but she was charging actually retail plus. She was charging retail prices and then booting her 20% markup on it. So like you could go to the mart, and if it was like a couch that she charged $1,200, you could go to Ralph Lauren on Michigan Avenue and buy it for $1,000. You could go to the mart and buy it for $600, but she's charging you $1,200. We wanted her bills and records. We wanted her invoices. We wanted her receipts. Because we were paying all this, and I'm like, she defrauded you. Her contract said, I'm buying it from Mart, I'm giving you my discount. She's buying it from Ralph Lauren off their backyard dock. So we went and asked for her documents. So you would think that would be something she would provide. You would think we would be entitled to it, because that's money, right? they refused to give it to us. So I had to go in for a motion to compel, and then they refused to give it, and I had another one, and then I got sanctions, and then like all these things. So that all happens in this pre-discovery phase of, and it's expensive. Like my client spent like $80,000 just trying to get the documents for a $150,000 claim. It was ridiculous. So, okay, pre-discovery. Then we get to, after that, after all the documents are there, and also depositions. You know, you've heard of depositions where you ask questions, you're under oath. It's a court reporter, they take down everything, and you listen to them. And so that's all part of discovery as well. So written or oral questions, and you take depositions. Sometimes you can have written depositions and things like that. But that's all about exchange of information and trying to find out the facts of the case and getting everybody in the same playing field. After that, you go to trial. So you're unable to settle out of court. You're unable to have, the mediator can't get it home. We're not in arbitration, we're in a trial, so we're not really dealing with an arbitration panel. She can't settle, she got to go to the court. You go to the court, and you've already decided whether it's a jury or bench. And I talked about that before, you had to decide about the jury. Way back when you filed your complaint, I want a jury trial. If you fail to do that then, you can't get one later. If you have a jury, you have a jury selection. They bring in a bunch of people in a box, you ask all these questions, you were on jury duty once, or you were on jury a couple of you guys. You know what it's like. They ask you questions, what do you do for a living? What are your interests? There's all these various questions. Sometimes the judge asks them, sometimes the lawyer, sometimes it's a mix. And okay, you're excused, you keep, and then you get your jury, and you panel the jury, and some alternates. Then you have opening statements. Now, we've all watched these legal shows. So legally in trial, very different than what you watch on TV. In an opening statement, you are not supposed to argue. You are supposed to say, the facts will show you this. The facts will show you that. You are not supposed to argue and make conclusions. You're not going to say, the facts you will hear say this, and that means that, and this is a bad person. It's supposed to be a statement as opposed to an argument. So that's the opening statement. Then you put on evidence and witnesses, and there's all these rules about what evidence goes in, no hearsay, no, that's not relevant, objection overruled, things like that, and that goes in. We've seen that on TV, and there is some truth to a lot of court cases that you see on TV about some of that stuff, how it goes in. Leading questions, are you allowed to ask the leading question? And I'm not going to get into the details of that. If you ever want to ask me about what's the difference between a leading and a non-leading question and who can ask what, I'll chat later. But so that's about getting the evidence in and witnesses on the stand. And then you have closing arguments. That's when you get to say, ladies and gentlemen of the jury, or Your Honor, you heard this witness say that, you saw this document do this, and you saw this, and this all means that this was a bad person, or this all means that my client is owed money, or I don't care what they gave you, I don't care what you saw, my client is non-liable, don't owe anything. And you make the argument. And that's when it's a lot of the waving of the hands and the impassioned pleas and everything else. So that's what you try to do in court. That's the closing argument. If there's a jury, there's instructions. Those are the rules that the judge and the lawyers figure out and give to them. So a jury instruction may say, if you find, there's three parties that are defendants. If you define that all three parties are liable, now you must apportion their percentages here. If you find two of the three, you must find their portion is here and excuse this. And they give you instructions. It's just the rules of how the jury, because juries have never done this before, so you have to give a little bit of guidance of what you do. Plus, it helps document why they came to the decision they did. And then the judge reads the verdict or a judgment entered if it's criminal, and they read the verdict, and that's what it is. So that's your trial. If you want, you can appeal in the civil and criminal section that we live in our society. You can appeal it. And you can appeal it and you can say there was an error of law because they got the law right. You go up the hierarchy ladder. This court came in with a decision, but they didn't follow the laws, whatever it is above them. Or the judge made an improper ruling. The law didn't allow him to make that ruling, so you can say there was an error by the court. You can't say normally, unless it's brand new evidence, you can't say, I forgot to put this document in, and this document's going to exonerate. I had it, but I forgot to put it in, so I'm going to appeal to put that document in. You may say, though, I just found this document that the other side withheld from us. It's brand new evidence I never knew. Can I reopen the case and make an appeal and reopen the case for the new evidence? So there's certain rules you can't, but there's limited areas of what you can file an appeal for. And you kind of, while I won't test you on this, one of the things you look through is you look through the hierarchy. Can I use the hierarchy to actually help me appeal the process? So, and then with appeal, when you have an appeal, you get it in front of appellate judges, and that's all an oral argument. It's always going to be judges. There's no appeal to a jury. It's to judges. And it's written briefs, and sometimes you get to have oral argument, but not many times. So like Chicago is what's called the first district in Illinois. There's a number of different districts. They geographically divided up. About less than 5% of all cases that are heard by the appellate court, the first district, get oral argument. So a lot of it's only done on briefs. I've been lucky once I argued orally in front of the first district. It was really scary because something you don't do. It was an area of law that actually was tangential. It's construction related, but it was insurance. And I had never argued in front of it, but it was really cool, and I won. So that was even better. So that was so I am in the books, Mike Hanahan appearing on behalf of that. So I have a little case that's there and everything else. But it was kind of intimidating because that bench is really high. They sit up 6 to 8 feet above you, and there's 3 of them, and you sit up there, and they just pepper you with questions. You start to make your argument, and they're like, Mr. Hanahan, this, well, what about this, and what about this? And they're like, boom, boom. You never really know what's going on. But it was cool. It was fun. So that's appeal. Any questions on a trial? You guys all ready to be trial lawyers now? Okay. The other binding one is arbitration. So I don't want to go and deal with the juries and all that other crap and all the discovery that I have to go through, all of this 5 years of dealing with the legal fees, and then I have to get an appeal. I don't want to deal with that. I want to go to arbitration. Arbitration is going to be made up like a panel of people that know what they're talking about. So what do? We go this route. Arbitration, you file a demand. It's kind of like a complaint, but in arbitration the demand could be, they promised to build me a house for $1 million. It cost me $1.2 million. They owe me $200,000. You don't have to have all the elements of the claim. You just have to make this demand. And they actually call it a demand, not a complaint. Then an arbiter is selected, and you can have, depending on the size of the case and depending on what's agreement, there's what's called the American Arbitration Association, and they're completely set up to have arbiters, and you submit your demand to them, and you pay your fee. And then they send you out a list of potential arbiters, and you pick, they give you a list of 5 or 8, and you pick your top 3, and the other side picks their top 3, and if it matches, the highest top match becomes your arbiter, and that's your arbiter. Or sometimes maybe a panel of 3 arbiters. So there's different ways you can do it, but you pick somebody. And most of the time, what you try to do is if you have a construction case, your arbiter is going to be contractor, an architect, an engineer, or a construction lawyer. They know the industry. They're not just a judge that's handling slip and falls and corporate decisions and everything else. They know the industry. So if I'm representing an architect, the guys in the panel I'm going to select are architects, and the construction lawyers that I know represent architects. And the contractor is going to do the same thing. They're going to pick on the panel the contractor and the lawyers that represent contractors. So sometimes it takes a little while to get that one person that matches or the 3 people that match. So you select your arbiter, and you're off to the races. You have to file an answering statement. It's kind of like the answer that you have to complaints. And it can be just like a paragraph. Yeah, I saw what they said. I don't agree with it. No, I deny. So it doesn't have the formality of the court system. There's not the motions to dismiss type process that normally happens. It's much less formal. When I go to arbitration, though, I always prepare it as a formal complaint because I would rather make sure that I have, in my own mind, processed and for my client, all the right elements. So when the arbiter looks at it, they're like, yeah, this is a legitimate claim. You get yourself a leg up because you're treating it as seriously as you would be in court. Other people don't do that. Sometimes I've gotten arbitration demands for millions of dollars that are literally a sentence. So that's because they don't have to. There is limited discovery as opposed to 600 gigabytes of documentation. It's an agreement between the parties of what you want to do. I put in my contracts for a construction dispute, we'll have 4 depositions, unless the parties agree otherwise, each 3 hours only. I've been in depositions that have lasted 5 days for one person, and I was the one taking it because we didn't have the restrictions. But I make sure for my cases that have, because I want to keep the cost down, and I want to make the other side work really hard to pick those 4 people. And they better be the right people. And I'm going to do the same thing, and I know what I'm going to do, so you limit that. So you don't have to spend the dollars of going through mounds and mounds and millions of documents and everything else. Now, sometimes it can get fairly large depending on what's at stake and everything else, but you try to use this non-court-based system to streamline the case and really kind of get to what the issues are as quickly and as cheaply as possible. That's the theory. Let's see. Unless defined in the contract after agreement, decision about the discovery falls to the arbiter. Sometimes the parties can't agree to what the exchange of documents are because you don't have it in the contract. But you want to have exchange of documents. Sometimes one party wants the 600 gigabytes and the other party wants the 5 meg. So you have to go to the arbiter. And the arbiter, during the process, listens to both sides and says, okay, why don't you give them 100 meg instead of 600 gig? Or, figure something out. And you get these masters of administration that understand what you're doing, and they kind of recognize the value of the case. Because why? Because they're construction lawyers, or because they're an arbiter that's been an architect. They know the size of the project and how many documents are going to be there. So they help you with that process. And then you can't have limited subpoenas. The arbiter actually by statute has power to issue a subpoena. So let's say I'm the owner and I'm suing the contractor. But at issue, the contractor had a window supplier that didn't provide the windows correctly. I'm not suing the window supplier as the owner because I have no contract with them. But I need to have that window supplier provide me documents or have somebody take a deposition. I can serve a subpoena on that third party, which is an order by the arbiter that they must provide documents or come as a witness. So you have some limited power out there like a court would do. You've heard about subpoenas and everything else. So you can get to those people even though they're not parties to the claim. That's called a third party. After discovery, you have what's called an evidentiary hearing. It's not a trial, it's a hearing. You don't have juries. The lawyers get in, they present their evidence, they sit around at a big table, it's not in a big courtroom. It's much more informal. The rules of evidence, hearsay isn't necessarily applicable. In an arbitration, the arbiter will be like, oh, I'm going to let that in. I can distinguish between what's hearsay and not. I'm good at that. So almost all the evidence you want to get goes in. And it can be written, it can be oral, it can be documentation, it can be pre-written depositions. It's kind of what it's kind of like the recipe that the parties want to come to an agreement with using the arbiter. How are we going to get both sides' facts presented to this arbiter to come to a decision? So like I said, witnesses, but possibly, maybe not. No, we're not really going to have objection overruled. That stuff isn't going to happen. The arbiters can ask questions. They can I may be asking questions of, I'm representing the owner, and I may be asking questions of the contractor. I've been in arbitrations where this happens. I'm in a line of questions, and all of a sudden the arbiter's like, Mr. Hanahan, hold on a second. And then for 20 minutes, the arbiter asks questions that have nothing to do with what I'm talking about. And what do I do with that? I listen to that guy or that woman, the arbiter, because they are hearing something that I may not have thought was important, but they do. So now, if I can figure out where the arbiter's thinking about, now when I get my time to ask questions again, I need to make sure that I'm buttoning up those areas of questions. And then I'll finish up my stuff because I think whatever might be important. Sometimes it's nice to hear an arbiter ask questions. You're like, ooh, that's an angle I didn't think of because they're pretty smart too. So you use that to your benefit.
Is the arbiter, is that his profession or is he also someone that does other things? Is he a judge in a way?
So the answer is it depends. In most instances, the arbiters that are out there that in the construction industry, in most instances, they are practicing professionals that maybe a little bit later on in their career or just because they like it, spend part of their practice in generating revenue as being an arbiter. So one of my partners, the partner that taught this class before me, he's been an arbiter for 25 years, maybe longer. So he has a full, thriving legal practice, but part of his book of business are the arbitrations that he does, and he gets paid an hourly rate, just like he gets paid an hourly rate for that. As you get more senior, so Mark is his name, so he's probably in his mid-60s, maybe, I don't even know, I don't know if he's 65 yet or not, probably close. He does arbitrations a lot more than he practices. And then you get a lot of retired judges who, after a certain number of years on the bench, 30 years on the bench, they're done with that. They have their pension. They're like, okay, but I've been resolving disputes with people for years. And so there are companies that, like there's this one company that we use all the time called ADR disputes, Alternative Dispute Resolution disputes. And 75% of them are retired judges. And that's all they do. And so now when I go to them, and they do all different kinds of things, but they have their construction litigation judges. And so when I file an arbitration, mediation or arbitration with them, because they also do mediations, when I file a claim with them, I'm like, I want to use one of these 4 judges because I've appeared in front of them for years anyway, so they know me and they know the law. So it could be practicing, end of your career, or retired. Question. So it's not regulated. That's an interesting question. It's a really good question. It's not like a judge that has to be sworn in and everything else. Although in here, in the state of Illinois, in many states, you don't have to have any experience to be a judge. You just election. It's in Illinois you're elected to be a judge. Federal judges are appointed. You don't have to have ever been anything to do with the law. You could be a guy that owns a pet store, and if somebody likes you in the federal system and they nominate you and you get through the Senate, you're a federal judge, and that's a job for life. So there are no rules about being a judge necessarily other than politics, really, at the end of the day. Now, it's always better to say you're a practicing lawyer and you have some credibility, and if you have to go through a Senate confirmation in the U.S., then sometimes you get knocked out because you just ran a pet store. But what happens to be a part of, like the American Arbitration Association, the only way they will let you be an arbiter is you can take a series of classes with them. And it's a long process. It's not like I'm going to do, a couple things on a webinar and I'm going to be an arbiter. No, you have to pay its expensive fees. It takes over a year. Then you have to kind of shadow someone. And so they have a fairly expensive training process. And then that's a big kind of proving ground for arbiters. And then some of these independent companies, there's a company called Jams and Dispute, there's this ADR Systems, there's a couple other ones. And what happens is a number of the arbiters that are associated with the American Arbitration Association also will get an affiliation with them. They get a big enough name that they can now go with the bigger company that gets them more fees, gives them another avenue. So sometimes they're a AAA judge and they're a Triple H arbiter and they're a Jams mediator. So it's kind of a cottage industry. Okay. So you have the evidentiary hearing, they ultimately gives an award. There is no right of appeal in an arbitration because the parties have agreed by contract that we will not use the court system. We will go and we will abide by what the arbiter says. Now there's a couple minor exceptions. If you can prove that the arbiter was biased, I didn't know that the arbiter's wife was the sister-in-law of the defendant. That's a bias. But if they get the law wrong, if they just flat out get it wrong, you can't appeal it. Now, if it's so egregious that you can say that they're getting the law wrong with malice, that you can somehow show, not only did they get the law wrong, but they did it because they didn't like me, or you could just see the way there was, you could potentially appeal from that. But there's these very, very narrow windows. So the risk of arbitration, the benefit is faster, it's more streamlined, it can be significantly cheaper, as are all the benefits, and you don't have to deal with all the court crap and everything else. The risk is, if you get a bad ruling, you're stuck with it. And that has happened to me. I had a decision against my client for $625,000. It was worth $0. They blew it so bad, it was not even close. The case law was so in our favor. And I'm not the type of personality that would say, oh yeah, we really should have won, and we didn't. This one was so black and white. I don't know why this judge went the way, or this arbiter went the way they did, but they did. And I'm seasoned enough to never promise a client, so I didn't promise they were going to win, but I was shocked. My client paid $625,000. There's nothing we can do. That's just the way it goes with arbitration. So there's a risk with it. The other kind of downside, which is not in this lecture part here, is in the construction industry, because arbitration has become so much more, I would say, alternative dispute resolution, mediation, arbitration is probably 80% of how construction cases are resolved. 20 to fewer percent goes to the court system. But because of that, the cost and the speed is not nearly as efficient as it used to be. So because lawyers get involved and they want to do more discovery and everything else. I try to keep it narrow, but it can be more expensive question.
Is there a common law version of arbitration?
So common law, that's a great question. And the reason why is so you can help you understand. Common law is court-made law. As a term of art, when you say it's common law, it's because the court has ruled on the common facts of what's out there, and the court has created law. Arbitration doesn't have this stare decisis finding. So if an arbiter says 4 to 5 dentist survey say X, and the next people come and the exact same set of facts, the next arbiter does not have to follow those 4 or 5 dentists. They can say whatever they want. So there is no true common law in arbitration. That's another downside. Whereas in the courts, this whole stare decisis is law is built on the case and below. So in the example that I was giving before, like, the umbrella of Roe v. Wade, that's the law of the land, and everybody's supposed to follow it, and you have to have creative lawyers that want to come in and chip away at that or other laws, because the concept is, will you follow these rules? And that's one of the biggest questions that's asked in the Senate confirmation hearings for the Supreme Court judges is, will you follow stare decisis? Will you follow the rules that were created before? And not just Roe v. Wade, but a whole bunch of other cases. So common law is court-made law. Okay. Final thing is mediation. Mediation is a business resolution. It's non-binding. So whatever that mediator, they may be the smartest person in the world, they may get it 100% right of what the court's going to do, and both parties can say, I don't agree with you, and they can walk away. That's it. We try, but we don't agree. We're going to walk away. We're going to take our chance. We're going to roll the dice. We're going to go to court. We're going to go to arbitration. There's 2 types of mediations. There's what's called evaluative and facilitative. Evaluative is parties get together, they meet in the rooms, they talk, they tell what their stories are, they submit briefs, and then the mediator gives a written opinion evaluating the strengths and weaknesses of the case and tells them, I believe the case is worth $500,000 for the following reasons. It's a very detailed, thorough evaluation that is much more consuming, it's more costly, and you want to make sure you get a really good mediator. But if it's a big dollar figure, if we're talking things in the millions and tens of millions, I've mediated cases in the hundreds of millions, you want an evaluative mediation, and you want somebody that's a pro from Dover, somebody that really knows what they're doing, because you hire the best of the best because it's a big case and it's a big claim. That's evaluative. Facilitative, same thing. There's briefs, the people get in the rooms, they talk and they air their grievances and everything else, and then over a period of a day or two, this mediator runs back and forth between room and room and says, they want $1 million, what can you give me? 100,000? Okay, I'm going to go to this room. Okay, I got 400,000 from them. Well, I'm not going to tell you what I got from them. What are you going to give me? Because I got to get $1 million. And then you go back to the person with the $1 million and say, I'm never going to get you $1 million. So I can maybe get you like 300,000. What are you going to give me? Give me a different number than $1 million. And this person is literally a barter. And they're running around. I mean, they're going to give arguments. They're going to say why their case isn't worth $1 million. They're going to say why they should give more than 100. They're going to do some evaluation live. They're going to tell you what's going on, but it's the shuttle diplomacy. I'm going from room to room to room, and I'm going to facilitate the dialogue between. And my goal as a facilitative mediator at the end of the day or 2 or 3 days of mediation is to walk out of the room with an agreement of what everybody's going to pay each other. That's what I'm going to try to do. If I don't, the mediation is done for the day, and I'm not hired to write up an evaluation and write down why it should go one way or the other. I may still engage the parties for continued negotiation, but I'm not going to evaluate it in writing, critically thinking. So it's a shuttle diplomacy facilitator, a written opinion for evaluation. Mediation process. You're going to start out, you're going to have individual meetings with the mediator. You're going to submit, you're going to submit this mediation. You're going to call up the mediator, and you're going to have a phone conversation. You go, here's what the case is about. This is what I think it's about. The mediator's going to have a call with every party, and it's just going to be a dialogue. There may be limited exchange of documentation, and then ultimately you're going to get to a room. You're going to decide on a date. You're going to sit down, and you're going to have everybody air their dirty laundry, and then whether it's evaluative or facilitative, the process will go from there. I have a case right now where there's a large residential dispute, and we are going to have the first time we're all going to get together with the mediator is we're going to have a walk through the house. It's going to be the contractor, the architect, the owner, and the mediator. And we're going to walk through and see all the stuff that's wrong with the house. So he's just going to be an observer. But I want him to see the stuff himself. So later on, when I'm making the arguments of why the work was so crappy, he'd be like, yeah, I saw it. It's terrible. So I'm doing that purposely for that. Sometimes you don't want to have them so removed, but that's a process that you can kind of make up as you go. Mediations can be interrupted or continued. I've had mediations. We had like 2 days in 1 month, and then like 3 months later we continue because there's so many issues to cover and you're working with people's business schedules. And then you try for resolution. You do your best, whether it's by evaluation or facilitative, because this is a business solution. At the end of the day, I say to my clients, you're going to pay me X, you're going to recover Y. I know you're caught up in this because it's personal to you, but you got to make a business decision, or I recommend you to make a business decision, and here's what my recommendation is, and this is what the mediators say. So that's what you're trying to do, is kind of resolve it that way. And that's what mediation does. And I think we're done.